Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address the critical issues facing businesses and consumers today. Legal information, practical solutions, straight talk about a wide variety of topics from finance and family law to Social Security, workers' compensation, and more. In our last segment, we were covering personal injury. We started it. It can include auto accidents and dog bites, assault, battery, wrongful death. Anyway, it's a very hot topic, and we decided we would continue it today. But before doing that, as we end every program, we ask for your emails, and we did have emails. It was on a topic previously covered, but important enough that we thought we would address the two questions that were posed. So they're for Jackie Grasso and for David Bazar, our lawyers, our experts from ABCG, Audette, Bazar, Cordeiro Grasso law firm in East Providence. So here goes. The bank told us what they would accept for the sale of our house. We've since moved and are now carrying 2 mortgages. Finally, we got our price, and now the bank says that they want more money. We're very close to foreclosure. What can we possibly do?
Well, I think you need to negotiate additionally with the bank to see if they can be reasonable about the price, because you're facing a deadline, and the deadline is the foreclosure. If you can't get them to agree to it, then you have no other choice but to let the house go at foreclosure. And now that we're in the middle of a housing crisis, most of the banks are not sending debt cancellation notices out to individuals as long as the foreclosed house or the short-sale house was their primary residence. What that means is if somebody cancels a debt, the IRS looks at it as income. Under normal circumstances, the canceled debt would have to be declared on your taxes. The individual lenders nowadays are not doing that with short sales. If they don't agree to this and there is an ultimate foreclosure, they still have the right, if they choose, to go after the individual for a deficiency balance, which is what's left over after some of the mortgage is paid.
Certainly seems strange. You would think that the banks would want to have the house closed on and the money in.
Well, the banking industry right now is in their own mess, so to speak. You can't get through to the right person. You can call somebody on a Monday, and by Wednesday you have someone else. These people don't understand that there's a separate department called the Loss Mitigation Department that's dealing with all these short sales.
I suppose I should ask then in follow-up, does it mean that if they had a lawyer instead that would circumvent that problem from happening, or no?
It wouldn't circumvent it as much as there might be a better chance of getting it resolved before the foreclosure happens.
Well, that would make a difference now, wouldn't it?
Sure.
And by the way, with the short sale, the banks are paying the attorneys a certain fee, so it's not coming from the seller's pocket. The bank pays the attorney the fee. Same thing as they would a realtor.
And the second question we had was from someone who actually had declared bankruptcy. She writes, I had declared bankruptcy 10 years ago. I'm working and doing much better now. What do I have to do to begin getting credit? Will the bankruptcy be erased automatically? Do I have to call or write someone? How do I start? How do I start afresh?
Well, legally a bankruptcy, a Chapter 7 is on an individual's credit for 10 years. A Chapter 13 is there for 7 years. I would assume that she would probably have received already some solicitations from credit card companies. And my experience is people do qualify for credit not too long after bankruptcy. Doesn't mean that it's the end of life or the end of credit life for the individual. If it's 10 years is up, if it under a Chapter 7, it's completely off your credit report. It cannot be on there any longer. If it is, then you need to dispute that with credit bureau agencies.
Is it worthwhile for someone to check their credit to see that it's erased?
It's absolutely, to make sure your credit report's correct, you should always check it, even if it's not resulting after a bankruptcy. And what Jackie's saying, people have to understand, even if it's on their report because it should be, they filed bankruptcy 2 or 3 years ago, doesn't mean they can't get credit. In fact, some creditors look at them as the best risk because they can't file bankruptcy again for a period of time.
Not only that, their debt went from this to this. It was zeroed out because of a Chapter 7. That's what happens in a Chapter 7. The goal is to have all your debt discharged. As far as the credit report, people should know that you can get a free credit report, 1 per year, from annualcreditreport.com. And with that website, you can get all 3 reporting agencies. That would be Equifax, Experian, and TransUnion once a year, and it's free of charge.
Isn't it better to stagger those so that you're getting them at 3 different times of the year, or does it not matter?
I don't think it really makes a difference. Yes, you can stagger them. Yes, you can.
Good to know. Okay, so we had begun to speak about personal injury last time, and now I guess we're talking about slip and fall, negligence. Explain.
Where did we leave off? We started talking about auto accidents, I think. So I guess the first question you want us to delve into is what constitutes negligence and what kind of negligence can create a personal injury case. Is that fair starting point?
Fair starting point.
Okay. For lawyers, we have a lot of names for different things. Slip and falls cover a lot of different types of accidents. People who are injured when they fall on snow and ice, that happens a lot. And there's a couple of big differences between Rhode Island and Massachusetts when we talk about snow and ice injuries. You can have a slip and fall case that might result from a defect inside a building. We've had many cases where there were stairways that were defective, lack of railings, people who were working delivering to supermarkets where the loading docks were defective. So we'll get into each of those. They all raise different interesting issues. Which one do you want to start with, Jackie?
Oh, why don't we start with the railings?
All right, railings. There is building codes, as you know, for Rhode Island and every other state that have a requirement for railings when there are certain heights that people might fall from on stairways and so forth. A lot of times, either those railings are defective or they don't exist at all. And in that case, if someone's injured as a result of that, they can make a claim against the landlord, the owner of the property, who's responsible for maintaining or the design of the property in the first instance. We've had many cases where people have been injured in those situations. And what happens is, you want to get in with an architect or somebody to take a look at whether or not the property was properly designed in the first place or whether or not it was maintained properly. You can have a suit for either defective design or negligent maintenance.
Is that going to impact on how much someone is likely to recover in damages?
The damages are based on the injury to the person, not the amount of negligence. I often, in auto accident cases, which we talked about last time, have people come in and say, they rear-ended my car so hard I could have died. Well, you weren't hurt because you had a Volvo or something, so the injury wasn't quite as bad as it could have been, let's say. The amount of negligence doesn't impact how much you're going to recover. It's how badly you're injured. That comes to the point where a jury or a lawyer in determining damages will look at what your injuries are.
Is there a difference between what is actually an accident or someone having really maliciously done something? Is intent an issue at all?
Okay, let's step back a second and let's talk about all the elements of negligence. All right. The first element of negligence is, did the person who caused an injury act as a reasonable person would have done under the circumstances? That's your starting point. So the law requires everybody to act in a certain way, and it's a fictional character called the reasonably prudent person. So if you didn't act as a reasonably prudent person, you're negligent. You can act with such disregard for the safety and welfare of other people, that would amount to recklessness. And then if you get to a point where it's intentional, you've even crossed another line. All of those different types of activity or actions on the part of a person can be looked at in determining whether or not they're responsible for someone's injuries. But unless it's intentional, where you might get into punitive damages or something of that nature, the damages are all measured on the same basis. So the next thing you look at for negligence is their causation between the action or activity of the person and the damages that that person suffered. So if I rear-end your car and you're not hurt. You get out, you slip and fall in a pothole and hurt yourself and break your leg, for instance. Is the person who rear-ended you responsible for those injuries? That's the causation question. Probably not. It's not foreseeable, which is one of the standards that you look at for causation, that you could have a car accident, someone's going to get out, come to the